So in this webinar, I'm going to show that every time a request for buyer agent compensation comes over as part of an offer in California, a listing agent who's not an attorney is either going to breach their fiduciary duty or they're going to practice law without a license. This is a major risk for attorneys who are referring their clients to a listing agent. The good news is there's a lot more work for attorneys to do, and that work is highly valuable because it can help your, first of all, it can help your seller once they understand how to leverage buyer agent commission the way realtors used to. For instance, putting it on a brokered caravan and explaining to the agents that we're going to offer 3% or even 0.5% more if you get us an offer in the next 24 hours or within the next 2 weeks. I mean, the ways we used to do things, there are ways to leverage buyer agent compensation to get more showings, which usually means more offers, which means a higher net to your sellers. Realtors can't do that anymore. Realtors cannot negotiate down buyer agent compensation legally anymore. So they're going to hurt your client's net there. And every time they allow a seller, which could be 200,000 times approximately so far this year in 2025, every time they allow a seller to pay buyer agent compensation without talking to a lawyer and devising a risk mitigation strategy, they have heaped liability onto your sellers, and that liability could have been mitigated against, and in some ways it could have been completely eliminated. And we're going to cover that in this transaction. And the net at the end of all this is that listing agents are now at least as valuable. No, I'm sorry. Attorneys now are at least as valuable as the listing agent. And I'm going to show you, at least temporarily now, before you ascend to the full 50% or more, I'm going to show you how you can get $6,000 to $10,000 on every file out of the listing agent commissions for doing the work that has to be done in these files. Listing agents should be relieved that you're doing the work. So when you're referring a client to a listing agent, instead of getting $2,000 on the HUD or getting some kickbacks that would be illegal under RESPA and probably according to the California Bar Association, I'm now going to give you an avenue to make sure you're getting paid fairly. My name is John McConnin. I'm a real estate attorney and broker in California, and in the past, the California Association of Realtors has had me train realtors on how to negotiate multiple offers, which is part of this. That we're not going to cover that today. But the way I would do it is the most transparent way, and in my experience, it made the net go up, it made the final selling price go up, and it made real estate commissions go down. But we're not going to talk about that mechanism today, but I'll share it with you during a consult, and that's another extra value you'd be bringing to your sellers that realtors, they don't have the ability to do anymore, and I'm going to explain why. Am I going to do it in this slide? No, that was the problem. Well, here, the core conflict, which I just explained. It's either, when there's buyer agent compensation involved, it's either a breach of their fiduciary duty or they're practicing law without a license. But now it's this slide. So let me just say that the way the California Association of Realtors has designed this process, the buyer's agent, well, first of all, let's just go back one step. In the past, buyer agent commissions were paid out of the listing agent's commission. So, of course, the listing agent had the authority to negotiate buyer agent commission. It was the listing agent's money. So, for instance, as a broker attorney myself, and as a broker, I've sold about 200 homes. We would go to the listing agent and say, real estate, let's say it was a probate attorney. Listing agent commissions are 5%. We will offer 2.5% to the buyer's agent. So who's ever representing the buyer upon the sale of your home or your property, they'll get 2.5%, and I'll get 2.5% of that final purchase price for selling your home. If I represent both buyer and seller, then I could get, if I agreed with the seller ahead of time, I could do what we call double siding, and I could have gotten paid 5%. You would explain that during the listing appointment, and if sellers were commission concerned, they can negotiate down 4, so we'll go 2 and 2. Sellers had indirect control direct control of buyer agent commission during that agreement. Now, realtors got sued for 1.8, it was 1.6, 1.8, 1 point something billion dollars because it was said they were keeping commissions high, they were fixing commissions, and the DOJ said when a seller or a listing agent is offering buyer agent compensation, they can be breaching the fiduciary duty of the buyer's agent. By the way they do it, they can be steering, and steering still absolutely involved in this process. Just think about, I'll get to that in a minute. And keeping commissions high, that's still involved in this process. In fact, let me just make sense of that last statement right now for you. This is a California purchase agreement. Now, it allows the buyer's agent or the buyer to say, please pay my agent 3%. The rule or the process CAR set up is that the listing agents have no forms in which to counter, and they have no language to counter, and they have no ability to mitigate the risks that we just discussed. The risk of, when offering buyer agent compensation, steering, compromising the fiduciary duty of the buyer's agent, price fixing. So they've got no forms, they've got no language, and if you understand the Sipper case and what the Department of Real Estate says, they also have no ability to do this. Like, this would be what a counter should look like. Just one, myriad ways to present this counter. But I would say, let's say your seller, this was for a risk-averse seller, but let's say your seller wants to get the job done and is not that risk-averse, but they're like, I might as well protect myself if I can. Well, then, in this response, this is a counteroffer. So G3, they request the 3%, broker agent compensation. They explained to us they have no forms related to cooperating broker compensation, nor do they have any other forms in their database. I've looked at it. They say that's pretty much here. I mean, cooperating broker compensation is now buyer agent compensation. And we know that they set this process up so that the buyer agent has to agree, and what they're doing is writing 2.5 or 3% on here before they even show the property. That's their rule. That's not the California law, but it's the association's rule that all buyer's agents must have the amount they're going to get paid written in on this form, signed by the buyer before they even see the property. So think about that. The request comes over in G3. That request itself, if the seller agrees to it, will be creating liability, heaping liability onto a seller regarding steering, commission fixing, compromising the fiduciary duty of the buyer's agent. There are myriad. There's a spectrum of ways a seller can mitigate these risks, from fully to pretty good. Good enough for me, I'd say, if I was selling a home. So you've got good enough to 100%. That's the spectrum. Some of it could easily be accomplished with a few clauses and a few forms. But the seller needs to be explained, and they need to choose. So we've got, now you're asking me, well, why can't realtors do that? Well, this is what the DRE has said, and this is the Sipper case, the foundational case on practicing law without a license. This is what we learn in my broker training. I specifically remember in my broker training being told that realtors cannot even cross out. They are not licensed to do it. They cannot cross out a word in their contracts. And that's because of this. This is the Sipper case. If defendant had only been called upon to perform, I can't highlight it, but if the defendant could only be called upon to perform and had only undertaken to perform the clerical service of filling in the blanks on a particular form in accordance with the information furnished by the parties, or had merely acted as a scrivener to record the stated agreement of the parties to the transaction, he would not have been guilty of practicing law without a license. However, if you see our counter, this is the counter. So remember, G3 is checked. They're asking for 3%. If a seller doesn't respond, and if a buyer's agent doesn't help them write a counter, that request for 3% is automatically into the contract. Just by the way this works, right? You counter out the things that you're not accepting. So it gets accepted in this first round. So it's now 3% buyer agent compensation. Think about this. When your seller decided to list the home, they hired the listing agent to sell their home. There was no liability for buyer agent compensation heaped upon them. If they stayed at zero and didn't offer buyer agent compensation, they'd just sell their home. No risk. No extra, no new risk added upon them. But the minute they hire a listing agent who doesn't have any forms and cannot devise language or process, like I think you should bifurcate this into two separate negotiations, but they can't do that. And instead of explaining, hey, you need an attorney now, instead of the association giving them a form that says our forms allow buyers and buyer's agents to request buyer agent compensation. So if you're going to work with one of our realtors as a listing agent and our forms, you should speak to an attorney before you sign your listing contract. Because when you do, you're now in this process that allows buyers and buyer's agents to keep buyer and agent commissions high and lets the buyer ask the seller to pay for it. That compensation, the active compensating a buyer's agent, exposes you as a seller to compromising the fiduciary duty of the buyer's agent, to steering and to keeping commissions high. In addition, if you do it the realtor way, and this was discussed by many people, if you're offering inconsistent, if you're not broadcasting unilateral offers of compensation, you're also exposing yourself to risks of being sued by minority groups, or protected interests, I should say, protected groups, by offering levels of compensation that were different. So there's 4 risks that can be mitigated against that a listing agent cannot do. But instead of talking to an attorney, they're letting their sellers pay buyer agent compensation. So that's the risk, that's the fiduciary duty breach, the way realtors are mostly doing this right now. Now the second choice would be, well, what if the listing agent had some language from their office and they wrote it into the form? Well, that's where the Sipper case comes in. If the defendant had only been called upon to perform and had undertaken to perform a clerical service of filling in the blanks on a particular form in accordance with the information furnished him by the parties, or had merely acted as a scrivener to record the stated agreement of the parties to the transaction, he would not have been guilty. Well, clearly they're not a scrivener because this is counter time. So they're not recording the parties. Now, they're not actually just putting in language for a seller. They're actually making a choice. Are they going to try to carry out negotiations on this counter language? Are they going to find a way to mitigate the risks? Or are they going to ask, as I would do, let's say your seller, this is different than what I wrote here, but let's say the seller is like, if I sell it for $25,000 more than they offered, so 1.6 listing, they come in at 1.5, and he or she is like, if I sell it for 1.525, which I think we can get to, I'll pay that 3%, but I'd like to be protected from the risks of offering buyer agent compensation. Well, here, in that case, I would say something like, box G3 is hereby unchecked. However, seller is amenable to paying buyer agent compensation of 3%, provided buyer makes that request on a separate written agreement between buyer and seller, and it's not a term of this purchase contract. Those forms are attached with this counter offer. And in those forms, you could accomplish myriad things. Depending on how much work you wanted to put them through, you could accomplish virtually 100% risk mitigation with the right process. You can go somewhere from pretty good all the way up. For instance, if you read the class action suits, one of the major things I would want to see is that the seller explains to the buyer's agent that by offering buyer agent compensation, I'm creating these risks. So I'm asking you to waive these risks. Another thing is that you need to understand the buyers have been confused in the past and said, I didn't realize the money to pay my buyer's agent was coming out of my money. So we'd like you to acknowledge that the buyer agent's being paid by the money you offer to me, but we're paying your buyer's agent out of the funds you produced. I mean, I have gone through this in myriad ways I'm going to talk to you at the end of this, or maybe soon, about in my course. I've got the forms and the counter language, and I'm willing to develop all of it. Like, you're all going to have questions over time, and I will work on developing all this with you. But I have the forms, I have counter language, I have the possible counter arrangements, so that what happens in the end is when you have an initial consult with your seller, you explain to them that you might want to leverage buyer agent compensation. If you're going to agree to buyer agent compensation, you might want to do what realtors did in the past, because of levering it properly and mitigating against the risks, you might, in some ways, it might be safer than what the realtors are doing, and you should get more showings and more offers out of it, and you can put them all together in a tight weekend, be very compliant and transparent, and you might sell for a lot more money with lower buyer agent compensation. And you should give that a shot your first week to 10 days. After that, you can just go to the regular realtor way of doing things. But even that way, when you're working with an attorney and you break this out into a bifurcated negotiation, you can protect yourself, you can get a higher net, and you might get a higher selling price, and you might be able to reduce buyer agent compensation if you're unhappy with the offer, and you're willing to counter. So all of these things can serve your seller better, and all of these things are important. So what I'm saying is that first you educate your client, and you protect them, and we've got a form for that. It's my seller to listing agent form. And then when you actually, and maybe you can develop a lot more offers, but at some point when it comes down to one offer, you're going to do exactly what we said. You're going to choose language. You're going to, based on, maybe you'll do a market temperature check with the listing agent. You'll find out whether there's any new properties on the market, whether current properties are going closing, whether they've gone pending or closed. You might talk to them about how many calls you're getting on the property, how many showings recently, are any other showings going to bring in offers, or is this the only offer, or do we have multiple offers? So you take a market temperature with the listing agent. You talk to the seller about their risk aversion. How much do they like this offer? Is the money good? Are they thinking that they're willing to wait, or they want to do business on this one? What sort of hoops do they want to put the buyer through? How much risk do they want to take on with respect to these factors? So you design all that with your seller. You've defined the strategy, and then your seller sells the home. At the closing, you've done the work. I mean, there's a bunch of things I'll talk to you about, but there's other work an attorney should do. Absolutely, you should be working with your clients. If you've got the confidence or the area, if you've come up to speed on disclosures and how to disclose well. Disclosing well can bring in more offers, can give clients more confidence. They're not going to buyers more confidence. They're not going to reserve money. A lot of buyers reserve money in their initial offers, thinking, well, I might have to do a lot of work on the property. But if you've done a disclosure process and you've done it at the right time, when they're going through the property, your client's property gains credibility in their eyes. It produces more offers and better offers. Lots of things you can do as an attorney on these files to make yourself actually more valuable than the listing agents are. A great listing agent, that's another story. But in general, if I'm talking about the work attorney does versus the work a listing agent does now, the attorney's doing far more valuable work. The listing agent's going to be communicating when people call about the property, but in the end, you're not only doing these counters. And this might be why you'd want to work with me, and we can refer out properties together. Well, we'll talk about that in the consult. But in the end, the attorney's the one. Like, let's say they're $10,000 apart or $20,000 apart, and the listing in the buyer's agent commission's at 3%. There's a lot of room there on a $2 million property to take out $15,000 or $20,000 to get your client a little $15,000 or $20,000 more. A listing agent's they're not authorized to do it in writing. They're not licensed to do it. They have no ability to get on the phone and do it legally, but you do, or an attorney broker does. And that's a very valuable service, looking prospectively, that no listing agent can do. So I believe I've made the case here for you that you're entitled to a significant percentage of the buyer agent compensation, of the listing agent's compensation, sorry. And there's a few different mechanisms to achieve it. But one of the easy ones is that instead of just getting $2,000 on the HUD or the closing doc for file review, if you set it up and structure it well, and you do it ahead of time, and you've documented the work you've done, you should be able to ask for $10,000 on the closing docs. And there would be a way to do it that I think most that I've done in the past, not to the $6,000 level, but back in the short sale days, we were getting paid $6,000 to $10,000 for negotiating fees. So I don't see if we structured it similar that way again, I'll tell you there's a very good structure, and I'll also tell you there's a backup structure. And that's what we'll talk about in our course. So I could probably bring back the presentation. We've covered that. yeah, that listing a good attorney will not only protect their clients and bring up their net, or have a chance to bring up their net one negotiation at a time, they can also do it prospectively ahead of time to create more showings and more offers. Let me just get to the close. So for $297, and eventually when I work with all of you, this will become a course for attorneys that just want to do this but don't have a lot of showings. What I'm saying right now is that I think this would be really useful for all the attorneys who refer clients to listing agents, or attorneys who know a lot of potential sellers and want to be involved. So what I'm saying is, for $297, I'll go over. I've already done it in there. In our membership area, there'll be the forms that are going to form the foundation of this. I would expect you'll put some boilerplate in your forms at the end of them, but you'll see the different forms, the waivers, the acknowledgments that I think are important. I'll talk about the process, because it's not just the forms, it's the process. I'll share the process with you that protects your client and would help you get for more. And we'll do this in the 40-minute strategy. And I'll also talk to you about the different ways, and I think the backup way is very important, the different ways you'll be able to get $6,000 to $10,000 more on the file. Now, additionally, if you're referring out a lot of clients, there are other ways to do this, and I can talk to you about that as well during that strategy consult, because I've done that in the past. Back in the, well, it was, instead of just the short sale days, back in the foreclosure days, I set up brokerages with clients that allowed the people getting the files to get paid a lot more money without being real estate brokers. So it can be done. And so right now, I don't know how long I'm going to have this membership area, but it'll be, as long as the membership area is there, it'll be at least for a year. So I would advise you, when you go in there, to download the forms, if you care, and set up that consult. And I'm planning to keep the membership area open for a year for you. But if there's no interest, there's only 3 people that want to do this, I'll just talk to you on the phone and not worry about the membership area. Because I really don't know how many attorneys do. I mean, I know I have 3 or 4 attorneys have referred probate work to me in the past, and I know there's a lot of other attorneys that do it, and I've met realtors who have a business out of it. So I imagine in each city there's a bunch of lawyers, but I don't know how many there really are out there. And so in short, what I'm saying is, this is not a course. I haven't covered this from A to Z. It's really a consult. It's a professional consult. I'm going to show you how to do things. I'm pretty friendly. If you're stuck, I'll be there to explain things to you. But the idea is that for $297, if you know what you're doing, you're good. Now, what this could also be, let's say that, like this, I'm thinking about my friend who refers some work to me. When I share all this with him, which I'm planning to, he went away, and I told him we'll talk when he gets back, so that's why I put this together. When I share all this with him, he's going to have a choice of how he wants to be involved. And he's going to understand 90% of what I just said. So he's good. And when he sees these forms, he's going to know what he's going to want to do. Right now, I don't even think he's aware of how incompetent, legally speaking, listing agents are. But when he is, he's going to change his practice. He's going to structure it properly. And he's going to make these changes. I think this is the foundation. This is what he needed. Many of you are like that. However, some of you are like John. I've reviewed your, I got up on YouTube and I saw, I'm one of those people who commented on your or called you up about purchase agreements. I'd like to be able to counsel my client well in purchase agreements. I'd like to be able to counsel them well on doing disclosures. And I definitely want to talk to you when I'm counseling on whether they should be leveraging buyer agent compensation, or how to do it on a file by file basis. We have an absolutely great method for that. And if it's in San Diego, this is how brokers who are probate attorneys and everything have been able to get paid in the past for doing work with me. I consult them with on the file. They do the work. They get paid. So it's not like I'm inventing this. This is an extension of my practice. And there will be ways for us to work together depending on how much work you want to do with me. And I can even co-list these and refer them all over the state. Because in the end, if you're really serving your client well, you're going to need a broker attorney or you negotiating on these files in the end. I mean, it could be on any file. If your seller's not getting the max or exactly what they wanted, we might as well go in and save them some money in that final round of negotiation. And we're going to be able to do that. And we're licensed to do it. And I've got the experience to do it. I've worked on hundreds of files for sellers and buyers, but hundreds of files. So we've got methods that we can customize for you. We can talk about that. I mean, that might take more than a 40-minute consult. We might set up a second strategy session, which is fine. So my name is John McConnin. I'm a broker and attorney in San Diego. So if you're seeing this at listingattorney.com, just you'll see, set up. I haven't even named it yet. I haven't even done it, but you'll see a button to push right after this. Otherwise, go to listingattorney.com, and I will also provide. I haven't even done it yet, but an ability for you to set up a strategy session with me, or maybe even a phone call. So thank you, and I look forward to helping us help your clients sell for more and be more protected and expanding your practice. Thanks.